Title IX and the architecture of administrative injustice. To understand the systematic dismantling of due process in the United States, one must begin with a largely misunderstood mechanism, the Dear Colleague Letter, or DCL. These are not laws, nor formal regulations passed through Congress, but rather interpretive directives issued by federal agencies, often the Department of Education's Office for Civil Rights, or OCR, to shape institutional behavior by leveraging access to federal funding. In practice, they function as coercive policy instruments, binding schools to new legal expectations under threat of investigation or financial penalty. Nowhere has this technique been more consequential than in the reinterpretation of Title IX, the 1972 statute prohibiting sex-based discrimination in education. In 2011, the Obama administration issued a Dear Colleague letter that fundamentally transformed Title IX from a tool of educational equity into a quasi-criminal enforcement regime. Institutions were ordered to adjudicate sexual misconduct claims under a preponderance of evidence standard, abandon core adversarial procedures such as cross-examination, and resolve cases quickly or face federal scrutiny and possible funding loss. This created a national system in which criminal allegations were diverted into administrative venues structurally incapable of adjudicating them fairly. The result was a rapid degradation of due process, particularly for the accused, whose guilt was often presumed and whose right to defense was procedurally neutered. By 2020, the unfairness of these Title IX processes had become too visible to ignore. The Trump administration introduced procedural reforms, most notably restoring cross-examination and requiring live hearings. But these changes left the deeper architecture intact. Universities still acted as de facto courts, the standard of proof remained low, and the venue remained shielded from meaningful judicial oversight. What was added was procedural window dressing, intended more to immunize the process from criticism than to correct its structural failures. The Biden administration, rather than confront this core dysfunction, attempted to expand the jurisdiction of Title IX, reinterpreting sex to include gender identity and broadening definitions of harassment. While these moves were framed as civil rights progress, they did nothing to address the underlying due process crisis. Instead, they further entrenched the administrative framework, now widened to cover more behaviors and identities. The result was an even more expansive system of non-judicial discipline operating outside traditional legal constraints, with broader power and fewer checks. With Trump's return in 2025, the Biden-era expansions have been rolled back, but the underlying machinery of administrative adjudication remains untouched. In fact, Title IX continues to serve the executive well, not as a site of reform, but as a template. Its model of coercing institutional compliance via regulatory fiat, adjudicating criminal-like claims without legal process, and evading judicial accountability has become a blueprint for how other areas of governance are being reshaped. The problem is no longer confined to schools or sexual misconduct cases. Title IX is now best understood as a case study in how constitutional norms are displaced by administrative instruments, and how the erosion of due process, once begun under one party, is strategically recycled, expanded, and rebranded under another. The reversion to the 2020 Title IX framework under Executive Order and Department of Education Directive in early 2025 is often framed as a return to fairness, but it actually consolidates the worst aspects of bureaucratic adjudication. The Trump-era rules, which replaced the 2011 Obama DCL's informal guidance, introduced formal hearings and cross-examination, but retained the fundamentally flawed jurisdictional framework. Schools continue to adjudicate quasi-criminal allegations without full constitutional safeguards. The 2025 reinstatement maintains this dualism, window dressing of adversarial form without criminal procedural substance. The consequence is a hybrid venue, neither a civil courtroom nor a restorative tribunal, but a carceral-light administrative process that imposes stigma, expulsion, and career-ending judgments through truncated evidentiary standards and institutional bias. By lowering the adjudicative threshold to preponderance and confining the process within universities, entities incentivized to protect their funding and reputations, we enable punitive consequences without legal legitimacy. Moreover, the courts themselves are placed in a bind. Because Title IX operates within the educational funding ecosystem, claims of due process violations are only judicially reviewable after the fact, if at all. Exhaustion of administrative remedies is often a procedural barrier. Most affected students have already suffered permanent reputational and educational damage by the time judicial remedies become available. Thus, Title IX becomes a test case for state power exercised without legal constraint. Even the minor concessions of the 2020 rules, cross-examination, right to advisors, become tools for legitimizing an illegitimate venue. The real problem, why universities are handling criminal accusations at all, is never addressed. The 2025 reversion amplifies this flaw by doubling down on the internalization of criminal procedure within educational bureaucracy. At root, this is not a partisan matter. It is a structural distortion of legal principle. Accusation substitutes for charge. University tribunals substitute for courts. Social reputation substitutes for liberty as the targeted asset. It is the creation of a parallel justice system that has absorbed criminal procedure but discarded the Constitution. The administrative attack on procedural protections extends far beyond Title IX. In early 2025, the Department of Education's Office for Civil Rights, which historically handled civil rights investigations across gender, race, and disability, suffered deep staff cuts and operational restructuring. This neuters a primary institutional check on discriminatory practices in schools and universities. With enforcement capacity diminished, the letter of civil rights law remains, but its power to be enforced disappears. This is strategic, not incidental. Layoffs within the Office for Civil Rights coincide with a wave of anti-DEI executive orders, for example, Executive Order 14151, signaling a coordinated effort to eliminate institutional mechanisms of redress. Without the Office for Civil Rights investigatory and enforcement capabilities, individuals subjected to discrimination, whether based on sex, race, or disability, have no meaningful path to accountability within the federal apparatus. The same logic manifests in procedural strangulation, the narrowing of grievance definitions, the shortening of reporting windows, and the discretionary rejection of complaints deemed non-compliant. These mechanisms ensure that even those who attempt to use the system are filtered out by process, effectively replicating procedural exclusion through formal compliance. Institutions remain technically bound by Title VI, Title IX, and Section 504, but in practice, they are insulated from scrutiny. This is not administrative incompetence. It is a deliberate model of bureaucratic silencing, one that preserves legal formalism while evacuating institutional functionality. The result is a pseudo-legal environment where individuals retain rights, but no mechanisms exist to realize them. The agency structure becomes a Potemkin village, visibly lawful, functionally inert. In short, the procedural architecture is being preserved in name but erased in substance. Legal obligations are hollowed out, rights are converted into unclaimable entitlements. The system, as currently engineered, simulates justice but is designed to guarantee institutional impunity and prevent legal redress at scale. Beyond Title IX and the Office for Civil Rights, the re-engineering of due process is happening through cross-agency administrative rulemaking, most prominently within the Department of Energy and the Department of Health and Human Services. In June 2025, the Department of Energy announced a direct final rule to redefine sex-based discrimination, bypassing the usual public comment periods. The method here is honestly pretty telling. Remove the deliberative process itself by redefining rules in ways that just sort of evade public accountability. The pattern is emerging. Rules are implemented by fiat, stripping away both content and procedure. This administrative technique really undermines the Administrative Procedure Act, or APA, which requires public notice and meaningful comment. By treating procedural requirements as obstacles to be navigated, rather than obligations to be fulfilled, agencies are recasting themselves not as implementers of law, but as autonomous nodes of governance. This becomes even more dangerous when combined with a commitment to biological essentialism. The redefinition of sex as biological male or female at birth across federal agencies effectively reverses decades of anti-discrimination jurisprudence. These definitions aren't deployed neutrally, but instead serve as mechanisms to preclude claims of discrimination, especially by trans and non-binary individuals. So taxonomy itself is, in a way, weaponized as a gatekeeping device. This trend signals a shift in the ontology of federal rulemaking. Law is no longer interpreted to achieve justice or equity, but to enforce normativity through definitions. Procedure, which once served to mediate between state power and individual liberty, is transformed into a tool of exclusion, where the very criteria of standing, identity, and harm are manipulated to prevent access to adjudication. Administrative overreach, then, is not just about power expansion. It is about hermeneutic control, the power to define what counts as a complaint, a violation, or a person. When agencies govern in this way, they exceed mere deregulation and enter the domain of sovereign discretion, producing a soft form of executive rule unmediated by courts or legislatures. Project 2025 represents the blueprint for regime change within the constitutional order. Spearheaded by the Heritage Foundation and aligned with a second Trump term, this 900-plus-page manifesto calls for the mass firing of civil servants, consolidation of executive authority, and the abolition of independence in administrative agencies. Its goal is not merely ideological, it's architectural. It seeks to reconfigure the structure of American governance to function under unitary executive control. One of the project's core proposals is to invoke the Schedule F classification, a Trump-era executive order resurrected in early 2025, that allows the president to reclassify tens of thousands of federal employees as at-will political appointees. This basically eliminates the institutional continuity and professional independence necessary for neutral rule enforcement and replaces it with a loyalty-based enforcement class. Another feature is the dismantling of internal review mechanisms. Agencies are to be subordinated to presidential direction, and internal checks, like career legal counsels, inspectors general, or regulatory review boards, are to be either purged or structurally disabled. The goal here is to eliminate the deep state by making the state shallow, no depth of professional memory, no buffer between command and execution. This vision collapses the Madisonian separation of powers. It replaces layered institutional friction, meant to preserve liberty, with a streamlined chain of command oriented toward executive fiat. The legal system, in this view, becomes a tool of compliance rather than contestation. Due process is reframed not as a guarantee, but as a discretionary privilege, to be extended when politically expedient and denied when threatening. Project 2025 is not merely aspirational, it is in progress. The executive orders already issued, the personnel already replaced, and the legal definitions already altered point toward a systematic reformation of American law into executive-administered norm enforcement, with judicial review reduced to symbolic opposition. It is the legal crystallization of everything due process was designed to prevent. The collapse of due process in the United States is not a singular event, nor the result of partisan malice alone. It is the culmination of a long arc of administrative drift, where power detaches from procedure, where rights become optics, and where institutions, once designed to mediate justice, now simulate it. Title IX is only the most visible tip of a deeper iceberg. What began as a well-intentioned mandate to address inequality has become a test lab for non-judicial governance, one where guilt is presumed, definitions are mutable, and outcomes are engineered for institutional convenience. This is not the rule of law. It is rule by process, emptied of its legal soul. And what makes this transformation so dangerous is not its brazenness, but its subtlety. It masquerades as accountability while destroying the conditions that make accountability possible. It does not suspend civil liberties outright. It suspends the mechanisms by which those liberties can be claimed. It does not censor protest. It removes the procedural ground on which protest becomes meaningful. It does not burn the Constitution. It reinterprets it into irrelevance. In this context, the most urgent task is not merely to call for reform, but to learn to see where power is being laundered through bureaucracy, to see how the appearance of fairness has come to mask the absence of justice, and to see that when institutions adjudicate reputational death under the color of law, without courts, without cross-examination, without accountability, they are not just failing to uphold due process, they are erasing the very idea of it. But there is still time. The machinery is not yet fully locked into place. What is needed is not outrage alone, but orientation. A public that understands administrative governance, not as neutral infrastructure, but as an evolving system of control. Citizens must look beyond the headline cases and begin to track the mechanics. How terms are defined, how rules are issued, how procedures are replaced. In doing so, they can begin to reconstruct the scaffolding of legal consciousness that administrative rule quietly dismantles. This is not a call to panic. It is a call to lucidity. Justice is not dead, but it is being recoded. And only if we learn to read the code can we write a different ending.